Well, let's go straight into this conversation now. And the Legal Practitioners Fidelity Fund has released a comprehensive list of legal practitioners who have defaulted or have been disbarred or convicted of misconduct since 2018. Now, the list includes over 50 lawyers who were found guilty of stealing funds entrusted to them by their clients. Now, we have the CEO of the Legal Practitioners Fidelity Fund, Motlatsi Molefe, who's joining us live on Zoom to shed a bit more light on this development. Mr. Molefe, thank you so much for making time for us, of course, joining us from Malta this morning. Let's speak about why it is that you felt this was a step that you needed to take as the Fidelity Fund.
Thank you, Andy, and good morning to you and your listeners. The issue of theft by legal practitioners is actually an age-old story, but unfortunately, it is becoming even more rampant as the years go by in terms of the quantums that are basically stolen by legal practitioners from members of the public. And that in itself says, unless we take drastic steps, which we did not in the past in terms of the publication of offenders, and they literally basically hid behind closed doors whilst they knew that they were actually culprits in theft, made it very imperative for us to start making sure that we name and shame those that actually steal from members of the public, and even worse, steal from those that are the most vulnerable in society.
And you speak about that vulnerability because in most instances when one is seeking legal advice, they are in a somewhat of a fix, whether it is looking for, a deceased estate to be devolved or you're looking for a payout. So if you're looking at lawyers then that refer people to the Fidelity Fund, which is something that's also on the increase, where they say, well, if you have a problem with how I've dealt with your matter, go directly to the Fidelity Fund, they'll pay you. How are you hoping to change that messaging from lawyers to educate them that, well, even if the Fidelity Fund pays, they are still liable, but more importantly, educating the victims of the crimes as well, that they can still seek, damages directly from those lawyers instead of the fund as well?
Well, Andy, I think it's a twofold message, really, which we have been trying to put across not only to legal practitioners themselves, but also to the public. Firstly, that it is in the interest of the legal profession that the fund remains sustainable so that members of the public can actually approach any legal practitioner with the full confidence that they will not be left out of pocket because of his behavior, which is unethical. On the other hand, we actually encourage members of the public to understand that the relationship between them and the practitioner is an agency relationship. So they need to know their rights. They need to know, for instance, that they're entitled to see what is going on in their files. They cannot be lied to. They cannot be misled. But even more importantly, that in the event they're feeling by a member of the public that there is something that is wrong, they should not hesitate to contact our offices to indicate that they believe that they are actually being misled about monies that are being held, or to contact the regulator directly to indicate what their complaint is so that we can move in as speedily as is possible in order to assist them. The problem most of the time is that members of the public take time before they actually notify us or the regulator of any wrongdoing that is taking place. And you find that by the time we step in, assets or monies have been dissipated or disappeared, and eventually we end up having to settle that. Now, members of the public need to understand that we are a fund of last resort. The Act requires that before you actually lodge a claim against the fund, you must have exhausted all your avenues to recover from the thief himself or herself. So, in essence, the sooner you move, the better. And I do believe that one of the biggest things that members of the public need to be aware of is that they also have to ask a practitioner before they entrust money to him or they entrust any service to him, that is he in possession of a valid Fidelity Fund certificate? Because if he's not entitled to receive money from them. And a Fidelity Fund certificate is only valid for the year in which it was issued, no other. So if a man shows you a Fidelity Fund certificate that talks to the year 2022 or 2023 and we're in 2025, and it doesn't produce a certificate that relates to 2025, he is to be avoided at all costs. Avoid him like plague, so to speak.
Yeah, and I think that's quite useful for viewers to be aware of. You did mention the concerns around the quantum a bit earlier on, and we looking at some of the names that were released by the Fidelity Fund. 6 million rand for one practitioner, Sheena St. Clair, 5 million rand for another, and we're looking at over 50 names then that you were able to release. Are you concerned that at some point, unless this does get arrested somehow, you would run out of funds then as the Fidelity Fund and you're no longer able to pay out what is due to victims of unscrupulous lawyers?
Well, that has always been a concern, Andy. Just to give you a simple example, last year only we received claims of around a total of 797 million, and we paid about 257 million. That's accumulated over the years in terms of what we had to pay. But in one single year, when you're notified of claims of 797, that talks to your sustainability. As a result of the question of sustainability, we actually approached the legislature. I think this is about at the time when the Legal Practice Act was being debated. But eventually, if you look at Section 55 of the Act, Section 55 of the Act actually says we would be liable for an amount determined by the minister from time to time by way of gazette. So in essence, from about 2 years ago in January, some 2 years ago, the minister gazetted an amount of 5 million rand per single claim. That talks to the fact that even if an attorney steals 10 million rands from you, the fund is actually only liable to the extent of 5 million rands, and the rest of the money you would probably have to try and extract from the fellow who stole from you or the lady who stole from you. But the long and short of it all is that was done to manage sustainability, because in the past, our contingency position was open-ended, which meant that, for instance, if there were to be a claim that actually sounds, let's say, for instance, the transaction sounded in pound sterling or dollars, and it turned out to be valid, let's say $1 million. When you do the exchange in terms of the rates, that would be a huge sum of money. And because it would be a valid claim, we would have had to pay it whether we liked it or not. And that could probably potentially have the effect of wiping out the fund overnight. So it had to be a situation where it had to be kept at a certain level in order to ensure that this social benefit fund continues to cater for every member of society instead of one individual who would actually simply collapse it through one valid claim.
So as we wrap up then, Mr. Molefe, for the viewers listening at home, it sounds like you're saying at the moment, due to the volume of claims against the fund, it's not guaranteed that they will get paid in full, particularly if it exceeds 5 million for an individual practitioner. In those instances, if I'm one now that's on the receiving end where a practitioner has exceeded the 5 million, where do I go to get the remainder of my amount if I can't get it from the Fidelity Fund?
Well, the first point, as I said earlier, is that you cannot come to the fund before you exhaust your remedies in relation to the offender himself. That is the party that must actually field the payment of any differential in money between that which we settle and the original quantum. But not only that, if you look at the Act says you may recover from the party who actually misappropriated or stole the funds or any other party that is in law liable. So, for instance, assuming a firm does carry fidelity cover, and it is only to the extent, say, of 5 million, the other 5 million can, in fact, be recovered from the insurer if there are such insurers who are actually providing fidelity cover for theft. Obviously, which is also a very difficult kind of placement to make in terms of insurance, because you anticipate your own theft or theft of employees, and the possibilities that with employees, they actually would cover you. But with respect to yourself, it probably will not be the case.
Yeah, we certainly hope this is something that will be abated as time does continue. But thank you so much for your time, Mr. Molefe, of course. Just shedding a bit of light on the new initiative from the Legal Practitioners Fidelity